call it to order, and we'll all just chime in. So it's Woody Chittick here.
Dave McMorris here.
Charlie Higginson here.
Lee
Darst here.
Matt Watkins here.
Great. Okay, and Cassandra is sitting in. One of her last times, I guess, Cassandra. But you never know. You probably have to fill in sometimes. Anyway, so we'll start with our regular business. The first.
Woody.
What?
Sorry. I'm having issues with getting attendees.
I can't follow you.
Can anybody hear me at all?
You're in and out. Mostly out. Are you at home or in the office? Can you use your iPhone? Any suggestions? I'm way over my pay grade on that one.
Yeah, I mean, I think when she rejoins, if she makes one of us a co-host, then we might have like the ability, if she was to drop, to maybe I could try to see if I can promote people, but it'll be a little dicey. But
I think you would be the likely candidate to
Yeah.
to co-host for sure.
Okay, so
but right now, I don't think any of us have that
capability
because I'm looking at the attendees and I'm not able to promote or do anything with it. So we'll maybe have to give her a minute.
Okay.
Yeah, because actually I see that Montana is one of the people in the attendees, but I'm not able to promote her.
I don't see her at all. I just see the five of us.
If you go to the attendees list, if you pull up the participants,
Oh, a lot of people. But Cassandra, can you promote Matt to be co-host? You're muted.
Sorry. I think I figured out the issue. Let me just double check. Okay. I think we're good. My laptop, for whatever reason, was trying to connect to my neighbor's Wi-Fi. I don't know why.
Okay.
Which isn't helpful when you're trying to have good Wi-Fi. So I can see attendees now. I've reconnected to my own Wi-Fi. We are good.
Okay.
Montana is with us, and I will make her co-host as a backup.
All right. Wonderful. All right, Kate. We've all signed in, if you will, verbally. And we'll take as our first hearing tonight, a continued hearing at 63 Nichols Road to reinforce a damaged retaining wall that exists now with a new wall in the floodplain. Do we have anybody that's going to, we had a fairly extensive presentation last month. I've seen no new materials other than a draft decision, which we have yet to discuss, but is there anybody wishing to?
Carmen
Yeah.
is here. There were no new materials submitted. Carmen is here. Carmen, if you wish to speak, you don't have to, but if you wish to, you can raise your hand. And I'm not seeing her hand raised.
Okay,
I did see, Cassandra, that on the website anyways, that the order of conditions was posted. I know we had asked about that. I see it's on the website, so I'm assuming either you got
Yes.
it or they submitted it.
Yes,
Either way.
Carmen did just raise her hand, so I'm going to promote her. But I did receive that from conservation.
hey, Carmen.
Good evening. This is for the record, Carmen Hudson from Merrill Engineers, which feels so weird because I've said Cavanaro Consulting for 20 years. So, yeah, so no new material was presented. The last time I think there were no standing issues that needed to be addressed. We hadn't been in front of the Conservation Commission yet, but since then we only had one hearing. It was approved and we submitted the order of conditions. The Conservation Commission actually didn't have any special conditions to put in the order. And the work is just about done. As you remember, this was an emergency situation. So if I'm here just to answer any questions that you might have.
Okay, does anybody on the board have questions of Carmen?
No.
Okay, in which case I think, and we do have a draft, right?
Yes.
So I think we could comfortably close the hearing. I'd make a motion to close the hearing.
Seconded.
Moved and seconded, all in favor, Woody Chidick, aye.
Dave McMorris, aye.
Roy Dickinson, aye.
Lee Darst, aye.
Matt Watkins, aye.
Okay, so that hearing's closed. We'll move on to the second one. 62 Spring Street, filed by the Suvacks, or Jamie Suvak in particular, to extend a front porch, which is a small one at present, and any other relief is necessary. Notwithstanding this board's questions and things, the Suvacks have requested a withdrawal for non-zoning reasons, I believe. So, in which case, our continued hearing would be moot. I would make a motion to accept their withdrawal request at 62 Spring Street. So, motion's made.
Second,
Okay, all in favor, Woody Chidick, aye.
Dave McMorris, aye.
Lee Darst, aye.
Matt Watkins, aye.
And Charlie?
Yes.
Okay, so that's officially withdrawn.
And John, on that one, I'd see they have active construction, but it's just to replace existing. Is that their new plan?
Yes, that's a new plan. We're out, they issued the permit for that. So it's basically the same size. They replaced the footings underneath it. Were kind of non-existing. So, yeah.
Okay, well, why don't we move on now to a continued hearing at 20 Parking Way filed by Heidi Condon of HC Design on behalf of Dr. Roger Pompeo to extend an existing deck and whatever other relief is needed. And the issue there, I think, we'll turn it over to Heidi, is one of a setback. Are they creating a nonconformity, extending a nonconformity, or complying in terms of our zoning bylaws? So there you go, Heidi.
Good
Okay.
evening. I'm Heidi Condon of HC Design. As Woody said, I'm here representing Dr. Roger Pompeo. You should all have gotten in your packets an updated site plan from Merrill Engineering. So I had Brendan Sullivan show the immediate neighbors on both sides. You'll see at the top of the kind of the north portion of Rogers property, the Rice Realty Trust building is 9 feet from the property line. And if you look directly south, the town of Cohasset's building is 3.5 feet from the property line. So that was our missing information from Merrill. That is what they used to calculate the setback along Parking Way. And that's where they came up with their 6.25 foot average setback. And that was in the addendum that we also provided, which you should all have. And so with the 6.25 setback along Parking Way, our proposed deck is 8'4" at the closest point.
That you're conforming.
So using that average, we are conforming.
The only small point on this Merrill plan is that it doesn't show how far away this Rice Realty Trust at 27 and 31 is. You know, you can't be more than 200 feet. I'm sure it probably is fine,
Oh.
but it's not indicated on the plan.
I see. I mean, I can scale it for you, but you can see. Do you want to know how far that building is from the property line or from Rogers?
From the building, from Rogers Building.
From Rogers Building? Okay. So the Rice property, using my scale, so this is a 1 to 10 scale. And the farthest point is 36 feet between the Rice Realty Trust and Rogers Corner property on the north side.
Okay, so that's well within, I mean, I think we need that statistic for a decision. You have 200 feet is the maximum, you're well within that, so it's not an issue. But we do need to cite that
Okay. And I
compliance.
can also, do you want how close the town Cohasset building is as well?
Well, I think you've,
I don't see it.
what?
I may just be misoriented here, but I don't, where's the town of Cohasset building?
It's
On the
it's
plan?
immediately south on James Lane across at the very
Oh.
bottom of your new
I see.
plan.
It's the rec center.
Yeah, okay.
And so from the building, and I'm counting the building.
Well, I mean, I think we could, yeah, it would be nice if you would scale it for us, but at least this building is shown.
Yes, and that's 63 feet,
That's what?
63 feet.
Away? Okay.
Yes,
Oh, yeah, I get you. Okay.
so I'm well within the 200 feet. And this deck will not affect the parking that's in front of that property line, so it's really not detrimental at all to the neighborhood.
I don't think you need to be in front of us, actually.
Yeah, it's by right.
I don't think we have jurisdiction to make a special permit finding here.
We just wanted to make sure that how we were reading that average is accurate.
I believe it's accurate.
Yeah.
Great. So then I do not need a special permit. We can apply for building permit by right?
Unless somebody has a different point of view on the board. Or John, do you have a different point of view?
No, just to kind of follow up on the situation. We were out in the parking lot today with the police chief on another matter, and we reviewed this matter. So just to confirm that the parking spaces that exist will not be affected by the addition. So he was clear on that, and I was too. So
Great.
Dave McMorris, I think what we need is just a statement saying that, you know, based on evidence submitted, et cetera, a special permit is not required, and leave it at that.
I think we just can put that in the minutes, can't we?
I suppose we could. Cassandra, what do you think?
I think that's fine.
Okay, great.
Excellent. Thank you.
Thank you.
Alrighty. Thank you.
Sure.
Okay, the next one is an appeal of the building inspector decision. The appellants, Barbara and Kevin Wren, have requested zoning enforcement, basically a lot cleanup and other things at 46 Black Rock Road. So we do have a lot of new material here. And I don't know whether John Hallen, I think, John, I'd like to hear from you first in terms of any accommodations or changes or status reports, and then we can have the appellants as well as the Harrisons speak.
sure, we did have a meeting with both the Harrison's lawyer and the Wren's attorney, Ben and Matt, and we did discuss and walk through some points. The main points being that we had Mr. Harrison agreed to remove the 2 truck beds and the truck itself. So that, upon inspection today, has been done. I think there's some photos showing that as well. So, you know, that has been done. The site there are all the vehicles on the site are, you know, registered working vehicles now. At this point, I think we're kind of left with, you know, from the original complaint, what is left to do. I think all the alleged violations have all been solved. So I think it's tough for the zoning regulations to put a time period on the job construction. They've moved along with the project. They've complied with the building code as far as that. They've made applications. They've addressed again, the outstanding permit for the temporary shed addition. I think whether they have, you know, when they have registered cars in their driveway is really not a concern for the board at this point. So I'm just looking for what is left to rule on. You know, I think that would be my only statement. As I say, I don't know quite what is outstanding.
Okay, well, that's a good jumping off point then. Is the Wren's attorney available, or do you want to speak to any other outstanding issues that there may be that are zoning related?
Matt Mitchell is in the audience, but he hasn't been promoted.
I did offer to promote him, and I'm not seeing him. Oh, he just popped back into the audience, so he might be having some internet issues. I'll promote him now.
Why don't we wait a few secs here? Okay,
Hi.
I see your face and can hear you.
I apologize for the delay. I thought it was going to be on a little bit later. So I'm not sure where we are at this point.
Okay.
I know that Mr. Harrison has taken the truck and the 2 truck beds off the property, which I think solves the original appeal. We did have a discussion at the last meeting, however, about the length of the project, and it's been going. I think the permit was issued in November, and from what I can see from looking at the project, the only things that have been done is the footings have been poured and it's backfilled, which should take about a week. especially since the soils weren't frozen over the winter time.
Can
And the
you-
other, go ahead.
Can you tell me how that's a zoning matter?
It's not. It was just brought up by the board at the last meeting. So that was my point. And the other point that we have is that, we've determined that Mr. Harrison owns quite a few vehicles, and it's not an issue now, but we just wanted to give the board a heads up that there's 13 probably rehabable, for lack of a better term, vehicles in Massachusetts and Vermont. So
Well, let me repeat Dave McMorris's question. How is that a zoning matter?
agreed, it's not at this point.
So there is no zoning matter before the board in this appeal.
Not right now. Mr. Harrison did what he was supposed to do under the
Okay,
good.
good.
Agreement that I had with Mr. Timon and with John Hallen.
Well, I appreciate that sense of cooperation. I think your letter to the board raised a couple of other issues that are speculative, ranging anywhere from there could be oil spill or leakage to an internal lift. Of course, the lift is not a zoning issue. Nothing inside is a zoning issue. And until or unless the Mr. Harrison decides to advertise, or not even advertise, but to charge money for automotive repair, he's got a hobby of repairing, which is legal.
Understood.
Right. Okay.
So is that, just a question for me, is that repair need to happen in the building as well, or can that happen anywhere?
No, it can happen anywhere. The zoning bylaw doesn't specify inside or outside.
Okay.
So just to clarify, so if there's any sort of advertisement or any sort of sale of the vehicles that have been rehabbed, that would be something that would not be allowed in the district?
I would say no, because automotive repair, commercial repair is not an allowed use in a residential district, but that hasn't happened.
Right.
So until or unless it happened, we really don't have any jurisdiction. And the first stop there would be the building inspector would point out that they were violating the table of use regulations, but it hasn't happened, so.
Understood.
Does this board have any questions of Mr. Mitchell or the Wrens? I mean, otherwise, I think that Harrison's, it isn't, and Mr. Timon, is probably not necessary even for you to chime in, given that, we seem to be lacking jurisdiction here.
I agree, Mr. Chairman, and it's a rare thing that I will be silent. So I concur with the remarks that have been made and would ask the board simply to deny the appeal of the Wrens. And I appreciate the time that the board and Inspector Hallen in particular have devoted to this.
Well, let's see, you could with, my question, I guess, is we could deny the appeal. The Wrens could withdraw if they wished.
I think that the materials that have been removed, I think they were a zoning issue. So
Right, okay.
I think that if we're going to do something, we should deny the appeal on the condition that, things stay out of the setback that don't belong there.
Right. Okay. All right, well, we could basically close the hearing, and then in our deliberation later on, we can just decide who's going to write it up and what we say.
I'm a little confused on procedurally how we do this. But
Yeah.
Well, I guess the board hasn't yet determined that there was a violation. I mean, the case was essentially settled, so I don't know what the vote would be. I don't think it should be a denial.
I think it should be withdrawn. Well, now, Dave, I mean, you know, the fact that they have moved a couple of trucks or whatever, I don't know. I mean, is this,
I think if they, you know, if they withdraw the appeal and something moves back into there, they always are able to seek the building inspector's help again.
right,
If
or
they're not happy, they
refile
can
if they
appeal to us.
feel, yeah.
I think that's probably the best course of action for us at this point.
Yeah, I'm not sure you'd want a denial hanging over.
We do not.
Okay, so I would.
I think there's something needs to be clear too, right? So that, I mean, John's not running down there for. Yeah, I think we can do that, but I went there today and I kind of like the way that the meeting's progressing because I think they made good progress. I think we charged them with going out there and kind of taking an inventory of what's there and cleaning it up. But some of the things that remain in the area are, you know, last time I think I was, I might have called it a bit of tomfoolery with the what was being put in the material pile, you know, but now what exists there is truly, you know, construction material. So it, you know, may not be glamorous to look at things like, you know, stones or dirt, but it's appropriate for the site, you know, so provide John some sort of coverage so he's not necessarily running down there for even like the dump truck that was in the photo that was submitted, I would think, you know, is a registered vehicle that is part of the construction. I think the things that were more flagrant have been, you know, addressed, which is good news, you know.
Yeah, so I mean, if the board could be clear on that, we'd appreciate it, because there's still other things that aren't construction material, like broken down lawnmowers and things like that on the property. So we would like for it to remain, let's say, clear. And if you could let us know what would be a reportable item on the property, that'd be really helpful. That way we wouldn't waste anybody's time.
Well, we typically, the zoning board does not take inventory of equipment or materials on property. We deal with largely, in this case, we'd be dealing with a use. Is this a non-commercial, you know, use, a hobby or whatever you want to call it, of Mr. Harrison, or is it a commercial use? And until there's some evidence indicating commercial use, I don't see that we are in a position to or allowed by the bylaw to take an inventory of you can have a kind of a yellow ride-on mower, but you can't have a larger John Deere. I mean, that's just not.
So just to the question then, so I can imagine that Mr. Harrison intends on repairing those pickup trucks that left the property that he was calling storage units for construction. What happens when they return on the property?
Are they registered? If they're registered, I think he's allowed. There isn't a limitation in terms of the number of vehicles that anyone can have in their property. There are limitations in terms of how close to the lot line they can be and so on and so forth. A setback 25 feet if it's 5 or more, I believe, but.
Yeah, okay, so I mean, the idea is if it's registered, then it's fine. If it's unregistered, it's not. Is that the dividing line?
Well, there's a limit. You can have unregistered vehicles as well.
Yeah.
Okay. But there's the bylaw is pretty clear about
All right,
how many
I'll
they can be in.
all right, we'll go read it then.
Yeah, and it's not going to be, you know, entirely precise.
Mhm.
As bylaws tend to be, but I think you can get the gist or what the intention is. The intention is to make a distinction between, you know, an automotive junkyard or graveyard and vehicles that are capable of running and being repaired. But and that's really kind of in the eye of John Hallen. If he feels that this is morphed into some sort of an automotive junkyard or graveyard, you know, with no activity, just a place to store inoperable equipment. I think he would have a friendly discussion
Okay, fair enough.
to make sure it complies.
Could I just say something, one thing for the record, Mr. Chairman? So I think it's important to point out for the record, first of all, that none of the sort of parade of horribles that the Wrens have speculated about are anything close to what the Harrisons have done, plan to do. They're not going to run a commercial facility. They're not running an auto body shop. They're not going to have a junkyard. They're engaging in a residential construction project, just like the Wrens are. And it's going to be very unfortunate if the Wrens continue to pepper Inspector Hallen with, things that they think are on the margins somehow because a lawnmower doesn't run. We're really getting into the realm of the silly here. And I do want to say for the record that the Harrisons have responded to every request. They're just trying to live their lives. They are pursuing a residential family use and a construction project. And unfortunately, these tensions arise with neighbors from time to time. But I would hope that the Wrens would not continue to burden town officials, and especially the Harrisons, with requests that are clearly inappropriate, like the ones that were put in that letter yesterday about how many vehicles are registered in different places. That list was flatly wrong in so many respects, but I don't want to get into any of those things because I think the board's absolutely correct that none of those matters are properly before the board. But I need to stick up for the Harrisons here. in
Okay,
the sense that-
but to kind of put a period on this, we can't and should not be empowered to determine whether a citizen is allowed to bring an appeal or not. That doesn't mean we have to have extensive hearings if we feel that the appeal is groundless. But you know what I mean? We can't have a decision that says thou shalt not appeal.
No, I understand. I totally agree, Mr. Chairman, but Mr. Wren was asking, for public guidance on these matters. And so that was what prompted my comments.
I think
There is public guidance.
what?
Public guidance is the bylaw.
Right.
It's on
Yeah,
the town website. It's actually pretty readable. Well, eye of the beholder again, but it's, the information is there.
yeah, it would have to be an obvious or an egregious violation in order for us to take action at all. That's all I can say. I mean, this is a hypothetical. And I don't think they want to harass their neighbors though either. I mean, that's pointless and probably not a good use of resources.
So is there a withdrawal pending here?
There could be. We could continue the hearing and
No,
hope to get a
but
withdrawal.
I'm sorry, I was muted. There is a withdrawal of the appeal.
Well, I move that we accept the withdrawal of the appeal of the building inspector's decision.
Okay, I'll second that. Moved and seconded. Woody Chitik, aye.
Dave McMorris, aye.
Charlie Higginson, aye.
Lee Darst,
Matt Watkins, aye.
Okay, so the withdrawal has been accepted. And any luck? We'll see you socially in town, but not by Zoom. But anyway,
Thank you very
All
much
right.
for your time.
thank you very much.
Thank you, everyone.
Thank you.
Thank you.
Thank you. Okay, the next, we have three bits of housekeeping here. There's been a request to continue the three applications at 94 Black Horse Lane, lots D, lots E, and lot 7A. Continue that hearing until August. I think they're in discussion with the planning board and the building inspector. And I no sense my I don't know the status of that, but I would like to make a motion to accept the applicant's request for continuance until August. And Cassandra, it's legal if we just lump all three appeals together, isn't it? Or do we have to have separate votes?
I think the way that Carolyn had you do it before is separate votes, just to be safe.
Okay, I'd make a motion then to accept the request for continuance at 94 Black Horse Lane, Lot D.
Seconded.
Second,
Moved and seconded. Woody Chitik, aye.
Dave McMorris, aye.
Bud Higgins and I.
Lee Darst, aye.
Matt Watkins, aye.
Okay, then I would make another motion to accept the request of the appellants to continue until our August hearing, the matter at 94 Black Horse Lane, Lot E.
Second,
Moved and seconded. Woody Chitik, aye.
Dave McMorris, aye.
Bud Higgins and I.
Lee Darst, aye.
Matt Watkins, aye.
Okay, so those two have been accepted, and the third request by the applicant to the appellant really is to continue until our August hearing, the hearing at 94 Black Horse Lane, Lot 7A.
Us, second.
Dave, you have a squeaky voice.
Yeah. It's bedtime, I think.
Yeah, okay, well, so I've made the motion.
I'll second it.
Okay, moved and seconded by Matt. All in favor, Woody Chitik, aye.
Bud Higgins and I.
Lee Darst, aye.
Dave McMorris, aye.
Matt Watkins, aye.
Okay, so that's all accepted. The last pieces of business beyond our little boilerplate.
Just to follow up, Woody, too, on
Sure.
94, they have met with their engineer and are in the process of putting together plans to submit to the planning board at this point. I did receive an email today and we'll follow up with that, but so they are making progress again to get the application into the planning board.
And the application is for what?
I think they're going to do a subdivision.
Okay,
Yep, that's the direction. We're trying to iron that out now, but that's the direction they're going.
good. All right. Well, that's a positive development.
Yeah.
That's good to know. Okay, so the last is this dock at 185 Jerusalem Road. They originally applied for special permit. It was pretty clear that their suggestion or plan would require a variance. A variance has been filed. The special permit is still pending. But we have not heard the arguments for or against a variance. This dock, I don't know procedurally how we handle with the special permit. Attorney Brodsky is here, so Adam, do you want to continue the special hearing perhaps so that we can launch into the variance? I don't think it makes any sense to do otherwise.
Good evening, Adam Brodsky for the applicants Ken and Adele Mars. I'm happy to defer conversation regarding the special permit to address the variance request if that's how you would like to proceed.
Yeah, I mean, I think the variance request is substantive and we need to deal with the pros and cons of that.
Yes, sir. With your permission, I have a short presentation, or as short as I can make it this evening.
Okay.
Thank you and good evening, everyone. I'm here with Carmen Hudson, our professional engineer, and Ken and Adele Mars are also in the audience. And as you will recall, when we last met on April 4th, the zoning board made clear that piers must comply with the requirements of section 305.2.h of the zoning code, which requires structures to be located not nearer to any side or rear lot line than either 15 feet or the permitted setback distance for a building on the lot, whichever is lesser. This property is located within the Residence C zoning district and requires a main building less than 15 feet in height to have a side yard setback of 15 feet. So our requirement would be 15 feet in this instance. As you may recall, and Carmen can bring up the plan when appropriate, the strip where we're proposing to locate the pier is only 6 feet wide. You remember that this is a rather unusual shaped lot with a, I don't know if it's a dog's tail or rat's tail, but in any event, the portion of the lot where we're proposing to place the pier and float is only 6 feet wide. The pier is proposed to be 4 foot wide, so the setbacks would only be 1 foot from each side yard. And as such, we need a variance under 300-5.2H, which we submitted to the board on May 2nd, 2023. I should note that we do not need a variance from the rear lot line because we're more than 30 feet, which is the rear yard setback within the zoning district, from the center line of the creek, which is our property boundary. As I tried to make clear in my submittal, the project satisfies all of the requirements for a variance under section 312.5A of the zoning code, as well as General Laws, Chapter 48, Section 10. First, circumstances relating to the shape of the property are unique and not generally found in the zoning district. Again, you need to look at the entire Residence C zoning district and not just the abutting properties. While I have the utmost respect for Mr. Lacey, who has far more experience than do I in this area, you need to look at the zoning district generally. And I don't think there's any question that the lot shape is unique and gives rise to the need for a variance when you examine the entirety of the zoning district. You may remember that Ms. Hudson had presented to you an aerial photograph that showed the neighboring properties and the location of various piers on Inner Harbor. And so we'd ask that you take that into consideration. Second, strict application of the bylaw will deprive the Morrises of reasonable use of their lot equivalent to surrounding lots. The assumption here is that given the configuration of this lot as well as the adjacent lot, that these lots were specifically configured to provide access to the water. As I indicated, this lot is surrounded by other properties with piers, including a pier for one of the abutters. It's my opinion, I think the opinion of others, that access to the water is a fundamental property right. That right is recognized by both the Wetlands Protection Act as well as the Public Waterfront Act, Chapter 91. As you know, the pier is proposed to be elevated over the salt marsh. And I'm just going to diverge just for a moment. Under the State Wetlands Protection Act, as well as the Cohasset Wetlands Bylaw, salt marsh is probably the most protected wetland resource area. There's a no alteration requirement. However, one is allowed under the State Wetlands Protection Act, as well as under the local bylaw, to construct a pier over salt marsh. And I think that's done for a couple of reasons. First is a recognition of property owners' right to access the water. Second, as a practical matter, it prevents alteration of the salt marsh by, for example, people walking across the salt marsh dragging kayaks to get their boats to the water. As a practical matter, Mr. Morris can't walk across the salt marsh, but he shouldn't have to in this instance. As a general matter, you're well aware that hardship under the Zoning Act is defined as not being able to reasonably use property in a manner allowed by municipal zoning. And for dimensional variances, even a relatively minor hardship can justify a variance. Use variances are a very different story, but we're talking here about a dimensional variance. In addition, the zoning code adds, your zoning code adds, that the reasonable use must be equivalent to surrounding lots. It's an additional factor. Piers are permitted uses within the residency district by special permit, and in fact have a simplified special permit process. In this instance, the Morrises just want to have the equivalent of what many of their neighbors have. And I'd respectfully suggest that a pier to access the water is a reasonable use of their lot. use of the lot in equivalent manner as to others in the zoning district. The third requirement is that the lot's unique conditions are not the result of action of the Morrisons taken subsequently to the adoption of the bylaw. And that's obvious. These lots were created decades ago, long prior to the Morrisons purchased the property. Fourth, a relief may be granted without substantial detriment to the public good or impair the intent of the bylaw. As we explained at the last public hearing, this pier can be constructed without trespassing on any neighboring properties. Unlike a dwelling or a commercial building, there's no traffic associated with the pier, no stormwater impacts or similar construction-related impacts. And in fact, construction of the pier will avoid potential adverse impacts to the salt marsh. As I indicated, it's a much better environmental solution than either walking across and dragging a boat across the salt marsh. I'd respectfully suggest that unlike building setbacks, which have a direct relationship to health and safety, in many instances, building setbacks were derived from the early building and fire codes to ensure that there weren't fires between buildings. And unlike buildings, unlike building setbacks, which also relate directly to density, there are no health or safety issues associated with the construction of a pier. And again, the construction of the pier is not going to result in congestion as considered by the zoning code. To the extent that there are concerns regarding safe navigation in and around the pier and on the water sheet, that will be addressed by Mass DEP. Under the Public Waterfront Act, there are very specific requirements for the construction of piers and how piers impact access to and from private property and affect navigation. That's not one of the purposes of the Cohasset zoning code. And I'd respectfully suggest that expertise in that area belongs to DEP and not necessarily the town of Cohasset. I'd also suggest that concerns regarding the views should not be a grounds for denial of relief. I believe Chair Chittick pointed out to me at the last meeting that one of the purposes of zoning in the zoning code is to preserve and protect natural beauty. But it's my experience that zoning claims based solely on aesthetic concerns are often unsuccessful because it's an entirely subjective determination. I personally don't find piers to be aesthetically unpleasing, but I suggest that really is not an appropriate ground to deny relief. Again, as I indicated at the last hearing, this pier has to go through an extensive permitting process. This is just the first step. Obviously, we need a special permit and variance from the zoning board. We're going to need an order of conditions from the Conservation Commission under the State Wetlands Protection Act, as well as under the Cohasset Wetlands Bylaw. We are going to need a Chapter 91 license under the Public Waterfront from Mass DEP, as well as authorization from the U.S. Army Corps of Engineers. And importantly, both the Wetlands Protection Act and the Cohasset Wetlands Bylaws have specific performance standards intended to preserve and protect natural resources. And I'd suggest that there are concerns regarding views and impacts on natural resources, that those issues be deferred to boards and agencies which have experience and I should add more definitive standards with respect to those issues. The zoning code also protects land values, and I think, as I suggested at the last public hearing, I think that cuts both ways. Not only does it protect land values of abutters, but also protects land values of the property owners seeking relief. And I'd suggest that property owners who are seeking to permit projects have an equivalent right to protect their property values. Importantly, there's no evidence that's been presented that the construction of this pier would cause an adverse impact or a reduction in any neighbor's land value. It's just an allegation, and no evidence has been presented of that. Again, I'll defer to the experience of the board, but my experience is often to the contrary. That in a handful of cases that I've been involved with, where there's actual evidence of value, that improvements to real property generally improve land values for the entire neighborhood rather than reduce them. And lastly, relief, if approved, cannot constitute a grant of a special privilege. Again, I've made this point repeatedly. I'm not going to belabor it. You simply need to look at the information that's provided by Carmen. There are at least 4 other piers on neighboring properties extending into Little Harbor. I don't see how the grant of a variance for an additional pier can at all be credibly considered to be a special privilege. With that said, I'm happy to answer any questions regarding my presentation. I don't know if there's any technical information that Ms. Hudson feels necessary to prepare. Again, I think we've demonstrated that we've met all of the criteria for the grant of a variance for the construction of the pier here. Thank you.
Well, anybody in the board want to take a first crack? And I think if we're going to talk about the conditions, the first hurdle you've got to go over is the uniqueness. What makes this piece of property unique that is not replicated or shared with neighboring lands?
Again, Chair Chittick, you need to look at the entire residency zoning district and
Oh, I don't think so, but I understand your point. I would disagree.
that's the requirement in the zoning code as well as the state act.
No, it applies, are unique to the applicant's lot and do not apply to the neighboring lands, structures, or buildings. Neighboring lands. Neighboring isn't 2 miles away. Neighboring is right nearby. So what's unique?
How many parcels in that district, Adam, if that is your case, how many parcels in that district abut the water but lack side setback? Are you saying this is the only parcel in the entire district? I mean, I've zoomed over the state's GIS, but I haven't calculated parcel by parcel. Is that your claim that this is the only one in the district?
No, Mr. Watkins, because I believe the adjacent lots are equally configured. But when we reviewed the lot shapes shown on the aerial photo that was prepared by Merrill, we were unable to identify any lots with a similar shape. So it's the shape of the lot with, again, I think it's called a rat tail. I'm not exactly sure. That gives rise to the unique condition. And again, I'm just reading from 312.5 A1. Conditions and circumstances are unique to the applicant's lot, structure, or building. It do not apply to the neighboring lands, structures, or buildings in the same district. And that
Right, emphasis is on neighboring lands.
I respectfully suggest that if you review the state zoning act, it talks about conditions in the same zoning district. That's where that language comes from.
Maybe, but I'm looking at the Cohasset bylaws.
Yes, sir. And you're not reading the entire phrase.
What?
The language in the same district qualifies all of the language prior to that.
No,
Why
it
is
makes
the word-
it.
Why is the word neighboring in there? Isn't it totally unnecessary?
I can't answer that, Mr. McMorris.
Yeah, yes, you can. You're a lawyer. You can answer that. The fact that it says neighboring is significant. If it meant just look at every other building in the whole district, then neighboring wouldn't be in there. It would just say in that district.
Not necessarily. Again, neighboring is qualified in the same district. So I don't think that the Cohasset bylaw was trying to diverge from what's required under 48 section 10. It's, I think, an articulation of what that state standard is.
Well, I think I beg to disagree. I think in the same district means you don't compare it to to properties in other districts.
Yeah,
You compare it to neighboring properties in that district. So if it's on the border of a district, you're only comparing the neighboring properties in the same district. That's my interpretation of it, and it seems to be a pretty logical interpretation of the actual words that are there.
and my
Again,
interpretation of the word unique is singular. This is the only one, as Matt Watkins said, not that there are others, or there are many, but this is the only situation of this sort in this neighboring area.
I reviewed the cases that I could find. I could not find a better articulation of that standard under the Cohasset bylaw. I'm happy to provide any number of cases to the board that talks generally about this requirement as articulated under 48 section 10, in which case the analysis is always done by looking at the zoning district. Again, I'd suggest the word neighboring is not defined in your zoning bylaws. A neighborhood doesn't necessarily mean abutting or immediately adjacent. A neighborhood can be comprised of blocks. Again, it's hard to discuss neighborhoods in a town like Cohasset, but neighborhoods can encompass square miles. And so if it said it has to be the only lot and you only compare it to the abutting lots, I could see the problem and the validity of your point. I'm reading your bylaw again in the larger context of the State Zoning Act.
Okay, you're welcome to do that. I'm not going to, however. I'm going to stay with the bylaw as Cohasset has drafted it and the Attorney General has approved it many years ago. And the two operative
And by the way,
words.
the word unique relates to conditions and circumstances that are unique to the applicant's lot. It doesn't say that the applicant's lot has to be the sole example of these unique conditions, Chair Chittick. And I don't think that's a fair interpretation of that bylaw.
No. Fine, we'll agree to disagree.
And if the board can direct me to any cases which articulate its interpretation of 12.5A1, please do so, because I'd like to educate myself.
Well, see, it doesn't make much sense to go further, like under 2, deprive the applicant of reasonable use of the lot, so on and so forth, unless you can prove that that the shape in this case is unique.
Yeah. So Chair Chittick, even assuming that the aerial photograph that you're looking at constitutes the neighborhood, I believe that there are only 2 lots which have this rat tail configuration. Out of the, and I'm counting 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, in excess of 20 lots just shown in this area. And I don't concede that this is the entire neighborhood. And so I'd suggest that 2 lots out of 20 are fairly unique.
Fairly unique,
Well,
maybe.
I don't really see the uniqueness of this anyway. It's just an irregularly shaped lot. I mean,
Well, Mr. McMorris, it's a regularly shaped lot, which the narrow portion provides access to the water sheet. So it's actually the shape of the lot gives rise to the need for a variance, which is the second requirement. There's a causal connection here, given the shape of the lot and the need for relief for, again, what should be a permitted accessory use of the property.
Why do you, we'll park uniqueness for the moment. Why do you think that access to the water or to a dock, or a float or something, is denied without a structure? Why other people walk down to the waterfront. I don't know of any other 185-foot long piers in this area or anywhere. I don't know of any piers that violate the required setbacks.
Chair Chittick, we're asking for the equivalent access to the water. As I've explained, we have salt marsh there. We don't wish to alter or damage the salt marsh. Even if Mr. Morris was physically able to walk through that salt marsh, he would be doing damage to it, which is entirely contrary to what we're trying to achieve under any of these regulatory programs. That's why piers are, I was going to say, routinely allowed. They are routinely allowed, so that you're not altering it and you're facilitating reasonable access to the water without adverse impacts. So requiring a property owner to damage wetlands to access the water makes no sense to me in the overall scheme of things.
Well, I think that's an accurate but very narrow view of things. When you're right, dock special permits are routinely granted. I mean, I know of, I don't know, maybe one or two that have been denied over the years. A lot of applications have come before us that we suggested that because of the side setback, they needed to move the location of their dock, and a number of them got within, got outside the setback with their dock and got their permits. This, I wouldn't consider this to be comparable to those docks. I mean, look at the overhead that you just had up. Look at the docks, and then look at this proposed pier and tell me that they're similar. They're not.
I'm sorry, I understand your point. I don't disagree with your point. But again, that's why the lot is unusual. That's why the lot is unique. That's why we need a variance, because we can't relocate this dock further away from any setback. This is the only place where we can construct a pier to gain access to the water.
But you don't have to construct a pier. You can leave it the way it's been for the last 60 years.
Of course, Chair Chittick, that's correct. You also don't need to construct a house on any lot in Cohasset or do any projects to improve your property.
Right, unless they comply with the zoning bylaw.
Or that you've demonstrated that you're entitled to a variance.
Right.
Right.
If we're looking at that first one, which is shape and uniqueness, I mean, if you zoom around, because I have the GIS up, if you zoom around other parcels in town that abut the water, there's a lot of parcels that provide a sliver of access to the waterway, whether it's, you know,
In the residency zoning district, Mr. Watkins?
I think there's some in the C district and there's a lot in other districts.
We're happy to take a further look at that issue.
But
If
so
you want
I
us
think-
to quantify that, if is that a sticking point, we can provide the board with an inventory of all of the waterfront property within the resident C district, and we can.
Yeah, but maybe not. That's.
I mean, I guess, yeah, before you get homework, I'm just saying, I think, yeah, a lot of folks are not embracing that type of a setup or parcel is unique, and that's kind of.
Yeah, you
the
haven't
trigger,
gotten
you know?
beyond uniqueness.
Yeah, I've not, and excuse me, let me close the door. I have a cat that likes to open and close the doors to the dining room. If you just give me a moment.
Yeah, go.
If I may, while Adam is gone, I actually was involved with a special permit that, just like this case, needed a variance. So then I have to file for a variance. And in this case, it was for 70 Border Street. And this was a pier that was approved and was given a variance. And that was a pier at this location. As you can see, there are 3 lots that are in the same situation. Now, this pier has not been built. It was approved, I think it's like in 2017, probably something like that. So this lot, its shape was a regular lot. Its uniqueness, if you were to look around, just the the immediate neighborhood. There were 3 lots that were the same. However, it received a variance because it was a variance to cross the front setback, because in this case, the pier had to be attached to the existing seawall. By the way, this 82 Border Street is the Lobster Pound, just for everybody to be able to locate this lot. Right now, there's nothing here. So this lot didn't have a particular special shape. Of course, the only use could be marine because it was underwater most of the time. But it received a variance to cross the front setback because it had to be attached to the front setback. So I don't understand, just from my personal experience, how a dock like this could be approved if the uniqueness wasn't there.
It's a totally different set of circumstances. They have nothing in common with each other. That's how you do it. And besides, we're not dealing with precedents, but somebody help me out here, Adam or somebody else. This lot, the present lot that is in question with this long right of way was created, what, 1957?
Chair Chittick, I just want to be clear, that's not a right of way. It is.
All right.
It is a fee parcel.
Great.
It has this
Okay, fine.
odd 6 foot long, I call it. a
This
rat
6
pit.
foot long strip of land was created when? 1957?
Hmm.
I think there was a plot plan or deed.
Yeah, I had that information, Chair Chittick, if you just give me a moment.
I think it was in your submission.
Yes, sir. That's what I'm looking at. 1957 plan.
Okay.
Mr. Perkins.
So from 1957 up until the present day, approximately 65, 75 years have gone by. How is the predecessor owners of this property, how have they accessed the water?
Chair Chick, I don't know.
So it's not this need is not something that has either existed for the last 70 years or has suddenly materialized.
Chair Chick, it could be any circumstance. Perhaps the people did not have the resources to permit and construct
Perhaps
a pier.
they didn't need a pier.
They may have had no interest in using the watershed. I have no idea. It's pure conjecture. All I can tell you is that the Morrises would like access to the water. They have accessibility issues.
That's not an excuse. That's not a justification.
As I said in my letter, Chair Chittick, it is not a in and of itself doesn't constitute a hardship that justifies a variance, and so I conceded that point. But it is the practical reality, which is that that's the only way we're going to be able to afford access to the water sheet for Mr. Morris here.
Well,
I don't
that's life.
see that there's any deprivation of the reasonable use of the lot compared to other owners in the neighborhood. I mean, all of the neighborhood people can access the water, walking through swamp or, marsh grass or whatever, or via a pier if they have one that's conforming and they don't need to impose on other people's property to do so. So I don't really see the deprivation of the reasonable use in number 2 either. I don't see number 1. I don't see number 2. I grant you number 3. I don't agree that there will it will not cause substantial detriment. I would like to hear from you as to from where, what areas in town will this pier be visible from? And it seems to me that if you look around through that entire map, all around Little Harbor, this will be the only property that would have a variance to build a pier. That seems to me to be a special privilege.
Mr. McMorris, I can't testify regarding how the other piers were permitted, so I don't.
Wait, you can just look at the properties and look at the docks. They're all set back from the sight lines and they're normal
Well,
size. So-
again, the zoning code requires not only side yard setbacks, but setbacks from the rear lot line. I don't know the seaward limit of ownership of these lots and whether or not, in fact, the board required that they comply with the rear yard setback. I think candidly that requirement has not been consistently enforced. So I can't answer your question in a principled way because I haven't done the research.
Okay. But looking at the overhead, seems to me this is visible from all of Jerusalem Road as you approach the water from the village, all around Little Harbor, probably, I don't have it in front of me, but I don't know about Bow Street, but it's,
Is anybody else seeing the agenda center document?
yeah. I
I think having that map up would be more useful.
Carmen's screen, I think, is being shared.
Carmen, can you please bring up the aerial photograph that we had submitted?
No, the wind,
This is the aerial photograph that shows the four piers.
It had a pier in blue, I think, or
Yes,
purple.
Yeah,
whatever it was.
it's right here. I'm sorry. Can you not see the aerial?
No, we can't. I think we're in your GIS somewhere.
Yes, okay.
Yeah, there we go.
so it looks to me like it's visible from Jerusalem, probably parts of Bow Street,
Parts of Nichols.
all of Nichols. I would guess across Little Harbor, all of Gammons Road, et cetera. You know, there's visual impact through a large swath of the town with this.
I don't disagree with you, Mr. McMorris. I think you could see the other docks in the area from those same vantage points. As I said, if the board is going to be considering the aesthetics of a pier and considering a variance,
Well, this is not aesthetics. This is not aesthetics. This is the difference between a 20-foot pier coming straight out from a person's property to the water and 185 feet across, kind of horizontally across the view line to the mudflat. They're not anywhere near the same thing.
and again, I'll defer to Ms. Hudson, but I believe that there have been similarly sized piers approved in other portions of Cohasset where there were concerns by neighbors regarding the aesthetic impacts of those piers.
Yes, so I can think of one right now. So let me see, and of course, these are just, projects that I have personally been involved with. How many there are in the town? I
I'm
don't know.
not talking about neighbors. I'm talking about
Oh,
half.
So this is, for example, a sizable pier here as well, which is within Cohasset. We have to, likely much longer than the one we have. There is one at 33. I'm sorry.
33 what?
I think it was 33 Cedar Lane. I just want to find it. It's right here. It was a similar situation at Radsdale, Marianne Murphy's property, and we constructed a dock here. Obviously much longer than the pier that we have at Little Harbor. The only difference was that so we in this case, this was approved under as a special permit. it crossed the rear property boundary because the mean high water and the mean low water elevation, I believe, were right around. So mean high water is here or somewhere here, and mean low water somewhere here. And the ramp went into the water with the float. So there was no relief that was sort of granted for doing that because it's the board's custom to allow that. And in this case, it had the 6 feet. So it wasn't 20 feet because this whole thing's 20 feet, but it had 6 feet of separation between the side property boundaries and the dock. And that we use I'm sorry. We use this section. I don't know if you can see. Can you see this, the dimensional table? So for that, we use this permitted accessory building, even though it wasn't a building, maybe constructed no closer than 6 feet to the sidelines and or rear lines of its lot if less than 15 feet in height and 100 feet in setback. So
Yeah.
that's what we use to approve this lot.
Okay, so this is a totally different circumstance, isn't it?
Yeah,
These
but
are not the same at all.
oh, of course not. And that's why this is unique, but the whole point was I was just showing this. I'm sorry. Hi, David. I see you laughing, but I was just showing, the question was, are there dogs that are this long? And there are, in fact, just from my personal experience in Cohasset, dogs that are longer.
And Mr. McMorris, I just want to clarify, the proposed pier is 104 feet long, not 185 feet long.
Okay.
The problem is you're trying to sort of both make an argument for uniqueness and one that would say there are very similar piers and docks all around. And in fact, they basically all complied with the bylaw. This is what makes this unique, is that it doesn't comply with the bylaw.
Chair Chittick, I draw a distinction. The question of uniqueness has to do with the first factor. Conditions and circumstances are unique to
Right.
the applicant's lot structure. We're talking about equivalent use. And again, if you're going to be judging our use to determine equivalency, you need to look at other properties. And again, there are numerous examples of other property owners with waterfront property who are allowed to have piers. And I don't dispute that we require a variance for this.
So I don't think you make number 2 either for that reason. You're whistling into the wind, frankly, here.
I think
Well-
this is the argument that you're making now. All of my neighbors have a garage and I don't have a garage. And the only place I can put a garage is in the setback because that's the way my lot is configured. That's not grounds for a variance, and that seems to be pretty much a parallel to what you have here.
Again, I draw a distinction. We're not talking about a building. We are talking about pier. With respect to, well, I understand that a pier is a structure that's subject to your zoning code. I'm talking about the purposes of setbacks. And the origin of setbacks derived from buildings and fire safety codes. The idea being is that
Not entirely, Adam, because a number of structures that are not buildings also have setback requirements.
that's true, including decks. And so you're concerned about privacy and density and things of that sort. This pier doesn't implicate any of those concerns or any of those purposes of the bylaw. That's why it's a pier and not a building. And so I'm drawing a distinction between the purpose of the bylaw with respect to protecting, for example, public safety and health with respect to buildings and the construction of a pier for access to the water sheet.
Well, I think that you may be right that that's, where the concept of setbacks derive from. But I would venture to say that virtually every resident of this town values their setback for reasons far different than access for fire trucks. It's the space, it's the privacy, it's not having a structure in your face on your property line. That's why we have setbacks.
And again, I don't know what the distance is from this pier to the nearest building. Carmen could certainly tell us, but I imagine it is hundreds of feet away. So there is no privacy implication here. Well, Carmen, you can probably, there's a structure that's right over here. I don't know how long that is.
Yeah, so
Maybe
we are,
20
this proposed pier is under 30 feet from the next door's pier. And I would say probably if this is 50 feet, maybe 100 feet to.
100 feet. Thank you.
Yeah.
I stand corrected.
Mhm.
So Chair Chittick, I don't want to belabor it. I've heard from certainly you and from Mr. McMorris, and you've made your views clear. I don't know whether if Mr. Higginson wants to weigh in. Unless you have any more questions for us, I'm going to ask for a continuance and consult with the client. I don't want to waste your time. And obviously, I don't want to invite a denial of request for relief.
Let me ask Charlie. Charlie,
I've been following this closely. I have nothing new to add. I do think that the setbacks are important and should be followed.
okay, so I think you've got a sense, certainly, of where the three voting members of this board stand.
Yes, sir.
We can render a decision, or we can, you know, if you wish to, as you say, file for continuance, or.
Yes, sir. I've asked for a continuance and I need to consult with the client. Obviously, we don't want to invite a denial of the application. And so I don't know if there's something that can be done to modify this. I don't think so. I don't know whether the client wishes to withdraw the application. But I don't want the board to take action, and as I said.
Okay, yeah, no, out of respect, I asked the board if it will accept your request, but Adam has made a verbal request to continue this hearing. Adam, a date certain, August, September, what's your pleasure?
Oh, certainly, perhaps even your next meeting.
Our next meeting is August. No,
July.
July, sorry, begging your
Yeah, so
pardon.
we
July
would,
11th
we
specifically.
would be probably continuing it anyways, right, Woody, for
Sure,
essentially a decision.
so why don't we, so
I do see too, there's a few, I mean, I know we received a few letters, but there looks to be some people with their hands up in the Q&A looking.
Yes,
make
there
comment.
are multiple members of the public looking to make comment.
All right, well, let's hear from the public, and then we can take action on the request to continue.
Okay. I'm gonna promote Ronald Goldberg, whereas he was the first one to reach out, but there are others as well.
Okay, Ron, you're up.
Okay, actually, Nina's gonna do it. Do you want to have the video?
Yeah, you can do video if you'd like. Okay. Hi, I'm Lena Goldberg, and I've been listening and following this very carefully. First, Woody, just a question. We didn't receive any notice that this was going to be a variance until we looked at it. If this is just a new application for a variance, should there not have been notice to the abutters? We found out about it, so it's not to our detriment, but just a procedural point. One of the things that struck us in listening to the conversation about unique, which to my understanding means one of a kind and only one of a kind, is that if you look at the aerial that was provided, the Maltz's property is the same rat tail. So if unique applies to an applicant's lot, which according to the bylaw it does, then you've got exactly the same situation with the Maltz's property. It too would be unique. And if a variance were granted here, then one would think logically, and as a matter of fairness, a variance would have to be granted to the Maltz's, and you would have two of these docks out there in very close proximity. And that's something that I think would have to be taken into account in consideration of whether one variance should be granted on the grounds of, quote, uniqueness, should there not also be a second one, in which case that obviates the entire definition of unique under the zoning code. Secondly, a comment was made that the proposed dock would be 30 feet from our pier, but only about 6 inches from our property line. And I think that the relevant consideration should be the property line, not the difference from the pier. But there's a bit of history of which you should be aware. When we applied for a permit for our own dock, we originally cited it thinking that we would be able to either get a variance or acceptance from the ZBA. We cited it where there's a pre-existing and non-conforming stairway down to the water. And I think that we used a firm that was very well known at that point. Carmen mentioned it earlier as one with which she worked. They told us that no, that wasn't going to fly. And our neighbor at that point, who owns the home that the Morrises now, who owned the home at that time that the Morrises now own, also said, wait a minute, there's a setback. So we moved our dock, we redid all the engineering to make certain that we could comply with the setback. And we thought that that would be something that would be applicable across the board. And as far as we know, it has been applied across the board with respect to a setback. So it strikes me that the setback has been applied in the past to people trying to build docks, even if they had a pre-existing non-conforming stairway down that had been in existence, presumably, people thought, at least since 1957. The argument has also been made that these lots were specifically configured to provide access to the water, with access being a fundamental right. Even if we accept that access is a fundamental right, which, by the way, I think is a matter of opinion and not a matter of law, specifically configured to provide access doesn't say what kind of access. It doesn't say you have the you should take that into account in providing for a very long dock with a float attached to it at the end. We appreciate that the dock has been shortened, and that is in part responsive to one of our earlier concerns that it really was too long, because if you also look at the aerial photo, even as the dock is currently configured, it does impede navigation through the mean high water over toward Nichols Road and Jerusalem Road. A lot of people put boats in right around the bridge over Jerusalem Road, the causeway, and their access would be somewhat impeded if they were going to go straight across the harbor at that point. We tried to keep our dock relatively short, and we only have access to the water at high tide. So we're on a mud flat for part of the time, and we have access at high tide, but we don't think we're impeding navigation, nor do we see any of the other docks in any way impeding navigation at high tide. This one, I think, this proposed dock would. And there was also a question of how did people access the water previously? Well, we knew our neighbors since we moved in 1987. They always walked right down, and they used kayaks, they used canoes, and they got them into the water right down. Now, if this were a proposal to build a stairway over the bank and then put a small float at the end of that stairway such that the water could be accessed at high tide, even if one had mobility problems, that would be an entirely different matter, I think, even with the setback problem. I'm certain that that could be worked out, but it's a proposal not simply to provide access to the water, but to provide a long gangway, which, having walked our own gangway to get to the water, anyone with mobility problems is going to have problems with that. So it strikes me that this is an attempt to get access to the water, and I sympathize with that. I don't think it's a fundamental right, because that would mean that anyone who really wanted access to the water could walk over everybody's property and do so, and that's not the case. You buy property knowing what the limitations are, and also knowing that it's subject to a code of regulations, including setback. it strikes me that this could be reconfigured to get access to the water the same way that previous owners had accessed the water, walking down the 6-foot strip of land, the so-called rat tail, which the Maltzes as an abutter also enjoy. So not unique 6-foot rat tail, walking down it, having a small stairway going over the bank at the end of it, which is not a very steep bank, having a small walkway and having a float that would be accessible just at high tide. That would be a very different application. So we request respectfully that this be taken into account. Thank you.
Okay, thank you. Next up, Cassandra.
So there was another woman who wanted to speak initially, but she, via the Q&A, just said that Ms. Goldberg brought up a lot of the same points that she was going to, and she doesn't want to speak anymore, but we do have David Maltz who wishes to speak.
Okay. Go ahead, David, you're muted. Unmute yourself.
Hey, can everybody hear me?
Yep.
Okay. I think the points have been made by others. You have a letter stating our points. The only thing that I would like to bring up is that in the letter by the Morris's attorney, it said that it wouldn't be a detriment to the public good. And I would ask the board to take a very good look at whether or not it would be a detriment to the public good. And in part of that, would it be a detriment to navigation at high tide, which was brought up as well. So I think that's the cogent point. I'm not going to repeat anything that anybody else has said. I would go back to the setback requirements. I think there may be one other thing, and that is when the lots were configured, and we are back to 1957, our lot, which I think has a 10-foot right of way, and I'm not sure whether the Morris's is 5 or 6 feet, and I originally thought it was 5, maybe I'm wrong, that it was set as access to the water, sort of as the way the Goldbergs were talking, a walking path to the water, not for constructing a dock. And then the only other thing is that the other docks that are in the general area did not require a variance for setback or access to the dock. So I think those are my points, but I would focus on detriment to the public good, and that I would say the board ought to consider that, because that was one of the points that the Morris's lawyer made about Adam Brodsky, that it wasn't a detriment to the public good. And I think I would take exception to that. Thanks for the time to speak.
Okay, thank you for speaking. Cassandra, who's next?
I believe that is all.
Oh, I thought we had a lot of people.
Well, there were 3.
Okay, that's less is better. So. Okay, with that being said, we've heard some concerns on the part of two abutting neighbors. I would like to make a recommendation to accept Attorney Brodsky's request to continue this until this hearing and variance request, as well as special permit, until our July hearing.
Second.
Okay, moved and seconded. Woody Chidick, aye?
Want to say?
Charlie Higginson, aye.
Lee Darst, aye.
Matt Watkins, aye.
Okay.
Thank you very much.
All
Thank
right,
you, Chair
thank you
Chidick.
very much.
Do you have the date of that meeting in July, please?
It's July 11th.
Thank you very much.
July
You're
11th.
welcome.
Good night. Thank you for your
Good
time.
night. Thank you for participating. Appreciate it. Okay, we have just a little boilerplate work. We're going to approve the meeting minutes of May 2nd. Is everybody okay with the meeting minutes? I've read them a couple of times. I didn't see anything that jumped out at me. Do I have a
Um,
motion?
They looked fine. I thought they were good.
Yeah. Do I have a motion
Accurate.
to approve the meeting minutes of May 2nd?
Seconded.
Okay. Made and seconded, moved and seconded, Woody Chitik, aye.
Dave McMorris, aye.
And Charlie and everybody and Matt and,
Lee Darcey.
okay,
Matt Watkins, I.
Charlie Higginson, aye.
great. Is everybody looking okay for the 11th of July?
Okay with me, Charlie Higginson.
Yeah, I think I'm okay.
Fine.
So why don't we kind of stay with that? I mean, if we were going to be running into a quorum issue or something, I'd want to know about it now. And the third item is Tom Callahan has once again requested that the zoning board put forward the name of one of its members to participate in the zoning bylaw committee. I'm not entirely sure how frequently they meet, but I think it's every 2 weeks. Cassandra, do you know?
It's twice a month, roughly every
Yeah.
2 weeks or so.
Every 2 weeks, roughly. So it's a time commitment. Does somebody, it's not required. This is we're being asked if somebody would like to volunteer. So I'm putting it forward to you folks. Anybody want to raise their hand and say,
I think I hear Michael Dickey saying me.
I've dreamed of this moment? Yes. Well, actually, Michael would be kind of, if I can use the word uniquely situated, having been a member of the planning board as well as the zoning board. The only one I know of. So why don't we sort of tentatively, I mean, Mike has got to say yes, but is that okay with the board? I mean, it's fine with me. I think he's probably well qualified.
Yep.
And he's dealt with at least 2 or 3 of the players in the past as well. So there's a sort of a personal relationship there.
And he won't miss any more zoning meetings.
He better not, because there'll be some environmental task force or something that Montana will come up with that we'll have to staff, and he'll be volunteered for that too. Okay, so I will tell David it's tentative. Cassandra, would you mind reaching out to Mike? I mean, or tell him I'd be happy to chat with him about what may be required, but he is probably better advised to talk to Tom Callahan. Since I'm not.
I will reach out to him when he's back from vacation and let
Okay.
him know that he's been tentatively volunteered to take that position.
Right, and don't spoil his vacation, so for God's sakes, don't tell him now.
Okay, I won't.
All right,
There is one other administrative item that
Okay.
was not originally put on your agenda. When I came on to be the liaison for you guys, you officially voted me in as your clerk to take minutes, but now that is going to be Montana's task, so you need to vote her in to take minutes, which she has been diligently doing, I'm sure, this meeting.
all right, we can't wait to see your minutes, Montana. I would like to make a motion then to elect Montana Castle or Cassell, how do you?
Castle.
Castle.
Thank you.
Montana Castle as our new clerk replacing Cassandra Thayer. So that motion's been made. Get a second?
Second it.
Okay, moved and seconded. Woody Chitik, aye.
Dave McMorris, aye.
Charlie Higginson, aye.
Lee Darcey.
Matt Watkins, I.
Perfect. Congratulations.
Thank you, guys.
Welcome.
Well, why don't you wait on the thank you?
Now, Woody, we also have, I did draft that decision for
Oh, for goodness sakes. Yeah, yeah.
for 63 Nichols. Hopefully everybody had a chance to take a peek, but I'll just, that's the one with the retaining wall that's largely complete. The only thing to note of it is, the decision was to, approve the reconstruction reinforcement of the wall, primarily under 308.7B. We did talk briefly in the meeting about, 9.7F, which allows for a driveway. In the decision itself, I just made reference that the wall itself is a support to the driveway, so we felt like 8.7B was most appropriate, but that, I acknowledged 9.7F just as the fact that the wall supports the driveway, but didn't really.
Yeah, I agree. I mean, I think we agreed last time that 8.7B was the answer.
Yeah, and I mentioned both, but I didn't get, I guess, in the weeds on 9.7F other than to say that.
I don't think you had to.
Yeah.
No, I thought it was a good decision. It was clear. And as you say, it's also not moot, but it's approaching that because the construction is well underway. So I'd like to make a motion to accept. The other thing we haven't done is really review the orders of conditions from the Conservation Commission. But have you had a chance, Matt, to look at those? We had testimony that this was pretty much, unremarkable.
Yeah, I referenced because it was on the town's website that they submitted it to us and it's part of the decision. But yeah, I didn't.
Okay, yeah.
It wasn't much notable.
Just if there was a red flag or something. All right, so I've made a motion to accept the decision as drafted on 63 Nichols Road. Second, moved and seconded. All in favor, Woody Chidick, aye.
Dave McMorris, aye.
Charlie Dickinson, aye.
Lee Darcey.
Now Watkins, I.
Okay, so that's moved and seconded. And now I'd like to make a motion to adjourn. And John Hallen, I've got my fingers crossed on Black Horse. I mean, really, it's not it's not our responsibility, but I think a subdivision is absolutely the way to go.
Yeah, I think that's the venue it belongs in, and that's where they could get the relief they need.
Yeah, so it's simpler and more comprehensive without any of the nasty, special exceptions. So good luck on that.
Thanks.
I have one question.
Yeah,
Are
please.
we like, I think we were doing Zoom through July. Is that the plan or is it extended?
I believe it was extended.
Okay.
Is this being extended because we in the select board meet at the same evening? If we met at a different day, evening rather, would it?
Well, the law was
person?
extended through the state in terms of having the capability to do the meetings virtually. In terms of on the town level, it really comes down to equipment and figuring out how to appropriately show the applicant's materials both in person and hybrid.
Meaning
That if there are going to be applicants in person, there needs to be equipment to show their materials to the board members during the meeting and then both participants online.
Well, I don't know if that answers Lee's question.
Well, no, I guess. Was it extended for a full year, the ability to have the meetings by Zoom? Or?
I think it was. I'd have to double check that. I could stand corrected, but I think it was extended for
I
quite
thought
some
to
time.
January anyway, at this point.
Yeah. It was a pretty large extension.
Okay. It's frankly a hybrid format. I think would work very, very nicely. There's some real advantage in meeting in person, but there are other people who can't get here or whatever, but who can access the meeting via Zoom. So it's really the best of both worlds if we can move toward that. I don't know. Is that the sense?
I think that might be the eventual goal, Woody. At this time, it would probably be a staffing and equipment issue that
Okay.
they have to get worked out.
All right, but as long as it's sort of kind of on somebody's radar screen that, you know, when it's appropriate, we'd love to have a hybrid format, but it is what it is.
Yep, hopefully by next meeting, I'll have a little more information on that too.
Great. Okay, well, we've dispensed with a fair amount and appreciate it. So everybody have a nice June. And I'll see your smiling faces in a few weeks. And Cassandra, you let Mike know that I'm happy to talk to him anytime.
I will do that.
Yeah.
Do we have a lot on the agenda for the next meeting already?
I believe the deadline for any new submissions is tomorrow. So as of right now, there are no new submissions, and you'll just have everything that was continued.
Okay,
So
Well,
less on the docket than there was today. But
we won't have Black Horse. What did we continue besides the 185 Jerusalem? There was a withdrawal, there was a conforming
That's it?
That's
pretty
it.
much, yeah, it was just the,
Unbelievable.
That's the only thing that's on here.
this
Wow.
actually might have been your fastest regular meeting since I started.
Do we credit Montana for that, or is it just an accident of nature?
Absolutely. I will take all the credit.
Okay, all right. Excellent. Okay, you guys have a great June. It's slowly starting to warm up.
Good night, all.
Good
Good
night.
night.
all.
you.
Thank
Good
you.
night.
Thanks.
everybody.
Bye.